Madam President, thank you very much for this opportunity to wind up what is a very important debate on a very important piece of legislation that this government has brought to this House in the interest of protecting the citizens of the Republic of Trinidad and Tobago while respecting the rights of every member of this society, even including convicted criminals. Madam President, I'm going to spend a little time so that we can renew our focus on the schedules of the two acts which are in focus today. The schedule of the 2019 Act and the schedule of that which will come back into force if we do not extend beyond the sunset clause. We remind ourselves, Madam President, of Section 5 of the Amendment Act which is before us today. Section 5, that is to say, of the 2017 Act, which we are seeking to continue in effect for another year. So when we look at Section 5 of Act number 17 of 2019, we are reminded that Section 5 of the Act then amended the Bail Act by repealing subsections 2 and 3 and inserting after subsection 1 the following subsections. So the current subsection 2 to the 2019 Act number 17 of 2019 reads, "A court shall not grant bail to a person who on or after the commencement of this Act is charged with an offense listed in Part 2 of the first schedule and has been previously convicted of an offense which is punishable by imprisonment for a term of 10 years or more." So we remind ourselves that those persons whose right to bail is circumscribed under the Act currently in force, which we are asking this Parliament to continue for another year, are persons who are already convicted of an offense punishable by imprisonment of a term of 10 years or more. And Part 2 of the 2019 Act, Act number 17 of 2019, was introduced by Section 6 of that Act and reads, Part 2, specified offenses. So these are the offenses which I draw to the attention of members of this august House, which currently obtain and in respect of which persons charged with offenses who have already committed these offenses are being circumscribed in their right to avail themselves of bail. A, an offense committed by a person over the age of 18 years under the Anti-Gang Act, which is punishable by imprisonment for a term of 10 years or more. B, an offense under the Offences Against the Person Act, punishable by imprisonment for a term of 10 years or more. C, an offense under the Dangerous Drugs Act, punishable by imprisonment for a term of 10 years or more. D, an offense under the Kidnapping Act, which is punishable by imprisonment for a term of 10 years or more. E, a sexual offense in which the alleged victim is a child. F, an offense under the Sexual Offences Act, punishable by imprisonment for a term of 10 years or more. G, an offense under the Anti-Terrorism Act, punishable by imprisonment for a term of 10 years or more. H, an offense under the Trafficking in Persons Act, punishable by imprisonment for a term of 10 years or more. I, an offense under the Firearms Act other than Section 6(1) or 2, punishable by imprisonment for a term of 10 years or more. And importantly, J, an attempt to commit an offense listed in this part. So that is the current state of the existing law, Madam President, which was brought into effect by Act number 17 of 2019, which we ask this House to continue for one more year. Those are very serious crimes, Madam President. Our failure, our decision today not to extend the life of that act will cause a reversion of the bail laws to what it was prior to the year 2019. And the detrimental consequence would be the reinstatement of the original Section 5 of the 1994 Act, which provides for the denial of bail for offenses where the accused is convicted on 3 previous occasions within the last 10 years. And we should remind ourselves of what Section 5 of the 1994 Act says. Section 5.2, a court shall not grant a bail to a person who is charged with an offense listed in Part 2 of the first schedule and has been convicted on 3 occasions arising out of separate transactions, A, of any offense, or B, of any combination of offenses listed in that part, unless on an application to a judge, he can show sufficient cause why his remand in custody is not justified. In calculating the 3-year convictions referred to in subsection 2, only those convictions recorded within the last 3 years shall be taken into account. So we understand immediately, Madam President, that when we revert to the pre-2019 legislation, what we are reverting to in that previous situation is Schedule 2 of the pre-2019 series of offenses which specify the following. So this is what we will go back to. Specified offenses. A, trafficking in narcotics or possession of narcotics for the purposes of trafficking. B, possessing and use of firearms or ammunition with intent to injure. C, possession of imitation firearms in pursuance of any criminal offenses. D, rape. E, sexual intercourse with a female under 14, which no longer applies as a result of other amendments. F, buggery. G, shooting or wounding with intent to do grievous bodily harm. H, robbery, aggravation with aggravation, armed robbery. I, larceny of a motor vehicle. J, burglary and housekeeping. K, perverting or defeating the course of public justice. L, arson. M, an attempt to commit any offense listed in this part or Part 1. N, receiving stolen goods. So those are that is the list of the specified offenses which this law will revert to should we not pass the legislation, the bill before this House today, to continue for one more year Act number 17 of 2019. Madam President, I say, notwithstanding the very many emotional arguments that we've heard, and I say that with respect, I don't mean any disrespect to anyone, that this reversion would be a very unfavorable step backwards for Trinidad and Tobago when one considers the risk posed to society by persons who commit or are charged with serious crimes and have been convicted of those serious crimes and are once more before the courts and are being asked by this Parliament to operate in limited circumstances under the discretion of the judiciary as to when and over what period of time they are allowed to go on bail until such time as they are fully tried as charged. The 2019 Act, Madam President, covers a 2-strike situation, which is wholly appropriate in the context of today's current crime situation. To revert to a 3-strike requirement before giving the judiciary the power to automatically deny bail creates, in our respectful view, an unreasonable hurdle, one may say an unforgivable hurdle in the fight against crime. There are reported situations where no objections have been made to bail. Of course, one may say that that is for the police to get their act together, but we have to deal with our reality in pragmatic terms. Part of the pragmatic terms with which we have to deal with our reality, which informs the fact, and I will speak to that shortly, informs the fact that I only this morning got statistics, which I have been asking for the past several weeks, has to do with the fact that we are coming out of a pandemic. Our systems are not up to the functional strength that they were prior to the pandemic. So for 3 weeks, I have been asking for statistics to justify the work that has been done in the last 3 years. I got some of those statistics this morning, and I go on record to acknowledge the hard work of the members of the judiciary, the prison service, and the police service, who, working under strained and constrained circumstances, have been able to give me that information today, have been able to give it to the Honourable Minister of National Security so he could have spoken to it this morning. We are not living in a perfect world. We are attempting on an incremental basis as a responsible government to keep this society safe, not to condemn ourselves to emotional appeals to create a crisis so that there can be some pretend basis to say the government has failed and voted out of office. Because when we do that, we are being reckless and we are exposing the citizenry of this country to the downfall of not being a responsible parliament. Madam President, what is equally worrisome with reference to the specified offences to which the former Section 5 applies when compared to the updated and comprehensive list contained in Part 2 is that we immediately appreciate when we lay Schedule 2, Part 2 of the pre-2019 Act alongside Schedule 2 of the Act number 17 of 2019, we immediately see the difference in the scope and application of specified offences which currently forms the law of this country and captures a wide range of criminality under, for example, the Dangerous Drugs Act, Kidnapping Act, Trafficking in Human Persons, and Sexual Offences Act. This as opposed to what is listed, and I have listed it, under the former Section 5, which included mere references to a few identified offences such as trafficking in narcotics and burglary, and matters which may carry a penalty of 10 years or more. Madam President, additionally, Part 2 of the 2019 Act includes offences which have been recently included into our body of law, such as the anti-gang and anti-terrorism offences. These are serious offences, and we cannot, with the greatest of respect, because we got the statistics late today, and I know it was a matter of legitimate concern, in particular for the independent senators, that we weren't able to put statistics to show what difference has been made in the last 3 years. But now that we are able to show some of those statistics, we cannot, with the greatest of respect, risk rolling ourselves back to a pre-2019 criminal justification basis to allow convicted criminals to roam the streets while they are being charged and are before the courts on similar offenses and continue to pose a risk to our young women, our children, our vulnerable, our elderly, and our right to walk our streets safely and to live in the comfort of knowing that the judicial system, the prison system, the governance of this country places the priority of the safety of all citizens as the foremost priority. Madam President, I have already in my pilot referred to the criminal justice system improvements which the Ministry of the Attorney General and Legal Affairs is engaged with, has accomplished, and continues to engage with. And may I go on record once again to pay tribute to the very hard-working members of the teams within the Ministry of the Attorney General and Legal Affairs. I have been humbled, I have been privileged to have assumed the office of Attorney General and to be served by persons who work until midnight, most nights, to provide the Attorney General with the material by which he can advise the Cabinet and the government on responsible governance, and I thank them. I have spoken in my pilot, Madam President, to the holistic approach to governance which this government must take, So today, when we speak to this Parliament to ask the Parliament to support the government to continue the legislation for one more year, we are not just speaking to one piece of legislation. We are speaking to a suite of legislation. And I will give just one example of the suite of legislation which is currently a work in progress, which I have inherited, which is part of the suite of legislation that we are bringing to this Parliament to keep our citizenry safe, of which this piece of legislation, this bill today, is only one. So we are working on the Offences Against the Person Amendment Act, categorization of murder, the Administration of Justice Indictable Proceedings Amendment Number 1 Bill, deeming of indictments, the Anti-Terrorism Amendment Bill, returnee bill, to deal with returning persons who have found themselves out in society such as Syria, the Interception of Communications Amendment Act 2020, the Criminal Records Rehabilitation of Offenders Bill, to find a way to give an opportunity for rehabilitation to persons convicted of crimes. The Miscellaneous Provisions Trial by Judge Alone Bill 2021. The act that we dealt with yesterday in the House, in that other place, the Miscellaneous Provisions Criminal Proceedings Bill, abolition of the year and a day, and relaxation of the rule against double jeopardy. All of that being a work in progress alongside with, simultaneously with, the bill that is before the Parliament today. The Miscellaneous Provisions Testing and Identification Bill 2019, polygraph testing. The Controlled Deliveries Bill 2022, the Firearms Amendment Act 2021 for regulation of the use of pepper spray. The arbitration bill in the civil jurisdiction to increase our capacity to resolve our disputes without always having to resort to the adversarial system of our justice system. Trafficking in Persons Amendment Act to seek to deter the commission of human trafficking offenses and to provide better care and protection for victims of trafficking. The parole bill, a comment was raised justifiably by a member of the independent bench. What about parole as part of the suite of legislation that we should be concentrating on, as opposed to simply trying to extend the sunset clause of the legislation, Act 17 of 2019? Work is being done on that as part of the comprehensive suite. The Evidence Amendment Act Number 2 Bill, witness anonymity orders to protect witnesses who have to live in fear of their lives when they have to come forward to give evidence in our criminal justice system. All of that, Madam President, is part of a suite of legislation which is being worked on in tandem with that which we have brought before this House today. The Honourable Minister of National Security has spoken to the improvements in the forensic science data, Forensic Science Center data, and I had intended to list that as well, but I am not going to because he's already been there. But the point is, we are working on an ongoing basis to improve our capacity to deliver justice, to provide for expeditious justice, to provide for empirically reliable systems and processes to bring offenders to justice, and to give a measure of psychological relief to the relatives of the victims of criminal activity who will know that their loved ones have been lost, maimed, or wounded, but that the justice system is working to bring the offenders to account. It is part of a work in progress. It is not simply one piece of legislation and therefore strike it out and embarrass the government into allegedly failing to combat crime so that other persons can have themselves celebrated for crying loudly, and sometimes one might say crying wolf. That is not how we govern responsibly, Madam President. Madam President, the statistics which I received today, I am able to tell this Honourable House Only this morning at about 8:30, having been asking for this information for the past 3 weeks, knowing that we were coming with this bill to the Parliament, knowing that we have a sunset arriving on the 5th of August, and we would be asking the legislators in this Parliament to do the responsible thing, to continue the legislation, because it is our view that that which we have already passed has begun to take effect, is being applied, and therefore it is justifiable that we ask senators in this August House to take that one further step, to give us that little bit more time in which to keep the men and women, the citizens of this country safe. I have been asking for it. I got it this morning, Madam President. It goes some small way to demonstrate that Act number 17 of 2019 truly captures repeat offenders. When I go through Schedule 2 of Act 17 of 2019, we are talking about repeat offenders. Yes, they have rights, and we have to respect their rights to due process, but they are repeat offenders from whom we want to keep this society safe. So it goes some way to demonstrate that the Act which is now in force and which we ask to extend captures repeat offenders and persons intent on repeating their criminal conduct. And we are saying that the data which has been provided illustrates that persons who were denied bail due to the conditions imposed under Section 5, 2, 3, and 5 of the Bail Act 17 of 2019 is working. The Criminal Records Office has pulled data from bail applications done before judges of the Criminal Division of the High Courts in Port of Spain, Tobago, and San Fernando. And I thank the Criminal Records Office. This category of data is important as it is reflective of persons who were firstly denied bail at the magistrate's court, or persons who may have been granted bail and who have now come before a judge in chambers to reapply for bail. The data shows that the total number of persons who were refused bail by a judge in chambers for the period 2019 to 2022, that is to say the application of Act 17 of 2019, totals 116 repeat offenders. Interestingly, Madam President, those 116 persons, of those 116 persons who were refused bail, 79 persons had as part of their criminal record over 5 additional pending matters for serious criminal offenses. Not 2, 5 additional pending matters for serious criminal offenses. And I'm not going to belabor the repetition of Schedule 2 to the 2019 Act to remind ourselves what those serious criminal offenses are. That is a percentage, Madam President, of 68% of persons who were denied bail with this legislation in place over the past 3 years and have had several pending matters for serious criminal offenses. Madam President, I was at pains when I piloted this bill on Monday to illustrate that the Act 17 of 2019 is truly intended to target repeat offenders. I was at pains to illustrate that the persons being denied bail before the courts and the persons within this country contributing to the increasing crime rate do in fact, and as a matter of court record, have a history of criminality. Yes, they have rights, and yes, we must respect their rights. We must give them access to the judiciary so that the judiciary, in due course, can adjudicate on their guilt or innocence on the new charges that they find themselves before the courts for. But we must give the judiciary in our less than perfect system time to process everything, and all we are saying is postpone their ability to apply for the bail whilst the system works through to ensure that those persons are not immediately allowed back onto the streets. So that the Act, Madam President, Act 17 of 2019, is working with the limited statistics that we have received in the constrained circumstances of the pandemic, which tells me certainly that the statistics may yet show more, but for purposes of this debate today, to appeal to the responsible members of this Senate, I think that we can say with confidence that we have put sufficient material on the simple statistics of 2019 to 2022 to show that the legislation which we are asking this Parliament to continue has not existed in a vacuum, has not existed as if nothing was done. Work has been done, work is being done, and in the meantime, the citizenry of this country are being kept as safe as we possibly can by a process of responsible governance. Madam President, as Attorney General with a commitment to progressive bail reform, I am optimistic that extensive consultation on comprehensive bail reform is critical. I commit to that, to include the Council of Criminologists with whom I have already engaged, because crime is not a phenomenon that is distanced from or separate from the society which gives birth to crime. Crime is a product of who we are and how, therefore, we must fix ourselves. And in the process of governance, we have to work at our societal improvements. We have to work at improving the quality of life for every citizen in the houses that they live in the streets that they walk in the schools that they go to, and that is what this government is committed to. And in the meantime, we, as a part of the criminal justice system, the part of the civil justice system, part of the administration of justice, are committed to doing the little that we can to come before this Parliament with properly drafted law to say to this Parliament, we need that little bit more time. A question was asked, Madam President, and I will turn to it immediately. A question was asked whether or not there are any precedents to this legislation. Well, I can say with confidence, Madam President, that, and I'm not going to cite them as precedents because I do not. I am not one of those lawyers who speaks glibly or without research and claims to know everything and every answer. I speak guardedly, and I speak with the maturity and the humility to know that I may be wrong. So I'm not going to misrepresent what I'm about to say, but I can say that there are other jurisdictions which are looking at their bail laws. New South Wales, Jamaica, Barbados, St. Lucia, Australia, and New Zealand are looking at their bail laws to amend their bail laws to refuse bail in limited circumstances so as to keep their citizens safe. We are not out there flying a kite because we are irresponsible and seeking to just keep people in prison. We are looking at the precedents to assist us in the responsible drafting process. And may I digress for a moment, Madam President? I got a text message last night from an Attorney General of another country in the Caribbean, asking if I knew of any good, serious draftspersons, because they need draftspersons. And I was able to say to them with pride, we have very good draftspersons in Trinidad and Tobago. And as much as I'd like to offer them to you, Mr. Attorney General, I said to my colleague last night, we have work for them to do in Trinidad and Tobago so that when we come to this Parliament with a bill such as that we put before this Parliament today, we do it with the confidence of knowing that it has been carefully drafted with reference to safe precedents, and we are asking the legislature to have the confidence in knowing that when they pass the legislation drafted by our Chief Parliamentary Counsel and his staff, it is responsibly drafted legislation, and I commend them. I digressed, and I beg your forgiveness, Madam President. We are committed to an ongoing criminal justice reform system which will keep this society safe. We, and I can speak for myself, I intend in the period that we are asking, that one more year, to return to this Parliament with more legislation with a view to looking at our bail reform generally, so as to take a holistic approach to bail generally. My good friend and colleague in this Parliament, Senator Vera, made some very interesting remarks on Monday, and I regret that he's not here with us today so that I can speak with him directly, but I know that he will pay keen attention. He made a number of suggestions for improvements in the legislation, which I am happy to say, some of which is already addressed in the very legislation that we are asking this Parliament to continue today beyond the sunset. So Senator Vera said on Monday that he would like to see community provision for community safety to ascertain whether or not the accused is likely to pose any threat to the society, and that ought to be a factor to be considered by the magistrate or judge when deciding whether or not to grant bail. Well, Section 2A1, Roman 2, Section 2A, Roman 2 of the legislation before us says, where the offense or one of the offenses of which the defendant is accused in the proceedings is punishable with imprisonment, it shall be within the discretion of the court to deny bail to the defendant in the following circumstances. A, where the court is satisfied that there are substantial grounds for believing that the defendant, if released on bail, would commit an offense while on bail. So that is already under consideration in this legislation, and we are going to improve it in the return that I promise we will make to this House on a more comprehensive bail reform. Senator Vera spoke also of wishing to see provisions for that employment of the accused ought to be a factor to be considered by the magistrate or judge when deciding whether or not to grant bail. Section 3B of the legislation that exists at the moment, which if we don't renew it will roll back, provides that in the exercise of its discretion under Section 2A, the court may consider B, the character, antecedents, associations, and social ties of the defendant. Senator Vera said that the family of the accused ought to be a factor to be considered by the magistrate or judge when deciding whether or not to grant bail. Well, under the present legislation, which we are asking this Parliament to continue, the judges have the discretion to grant bail within the prescriptions of the legislation. And one of the things that is prescribed for in Section 6(3)(b) is that in the exercise of its discretion under subsection 2A, the court may consider the following: the character, antecedents, associations, and societal ties of the defendant. He spoke to looking at community relations. Again, that will come in under Section 3B. And we have the catch-all phrase at the end, Section 6(3)(e). In the exercise of its discretion under Section 2A, the court may consider the following: any other factor which appears to be relevant. So that far from denying the judicial system oversight of the circumstances in which to grant bail, the existing legislation, which we ask this Parliament to continue, provides for some of the very considerations that legitimately trouble some of our senators here, and which this government commits to coming back to improve on in a more holistic manner, with the advice of relevant experts, including those criminologists that I have already begun speaking with, because I appreciate that it must be a societal product that speaks to who we are as a society from a proper socio-psychological and criminological basis. Madam President, Senator Lutch Medial today sought to suggest, and I say immediately, wrongly, that if this legislation is continued today, it will be an exercise in futility. My words, exercise in futility, because the Senate is being asked to pass illegal legislation. Well, that is, how shall I find a polite way to say it? A misrepresentation which I would expect on a more careful read of the law, Senator Lachmidial would correct herself on. In the first instance, the Achille Charles decision, which is on appeal to the Privy Council, doesn't concern what we are debating here today. The Achille Charles decision concerns Section 5(1) of the Bail Act. I only have to go to paragraph 1 of the decision in the Achille Charles decision of the Court of Appeal, the judgment of Chief Justice Ivor Archie, which is now on appeal and which the state has argued forcefully should be overturned, but that's another point. This is what Chief Justice Archie began his judgment with, paragraph 1 of his judgment dated the 17th of February 2022. The central issue in this appeal is whether Section 5(1) of the Bail Act of 1994 is inconsistent with the Constitution and therefore susceptible to being struck down. Let's look at the Act. Section 5(1) deals with the category of offenses specified in Part 1 of the schedule, which are murder, treason, and piracy. It does not have anything to do with Sections 5, 2, 3, 4, and 5, which we are considering under Act 17. So I have every confidence that when Senator Lachmidial reads the Achille Charles Court of Appeal decision, she will correct herself. Secondly, there is the decision of this very court, Madam President, a Court of Appeal decision, Civil Appeal P351 of 2016 between the Attorney General and Daniel St. Omar, a decision, a unanimous decision of Justices of Appeal Gregory Smith, Prakash Musai, and Peter Rajkumar, I beg his pardon, dated the 8th of March 2019. And I will read paragraphs 1 to 5 in the time left to me. The central issue in this appeal involves the court resolving an apparent conflict between two sections of the Bail Act, Chapter 4, number 60. Those are Section 5(1), we remind ourselves, murder, piracy, treason, and Section 5(5)(b)(2), other aspects of Schedule 2, which we are concerned with dealing with serious crime. Paragraph 2. Section 5(1) is a statutory affirmation of the constitutional right to bail, except as provided for in Sections 5, 2, and 4. Section 5(5)(b)(2) purported to take away the right to bail in certain cases. That's what we are about today in the discussion we are having, that Sections 5, 2, and others have limited the right to bail in certain other cases other than murder, treason, and piracy. Paragraph 3. An interesting twist to this appeal, I'm reading from the judgment of Mr. Justice of Appeal Gregory Smith. An interesting twist to this appeal arises because Section 5(5)(b)(2) was one of some temporary amendments to the Act at the time. Those amendments were in effect for only about 1.5 years. They lapsed on the 15th of August 2016. They were part of what is termed a sunset clause. Section 5(5)(b)(2) was no longer the law at the time of the hearing and determination of this constitutional motion in the High Court and on this appeal. Nevertheless, those appeals are not academic because the respondents were adversely affected since they were unable to secure bail, and counsel for the appellant informed us that the construction of this legislation may provide guidance in respect of future legislation on this very important area. In summary, paragraph 5, judgment of Mr. Justice of Appeal Gregory Smith. In summary, we find that on the relevant principles of statutory interpretation, the constitutional right to bail in Section 5.1 was not taken away by Section 5.5b2. As a result, neither respondent was deprived of his or her constitutional rights, and we therefore allow the Attorney General's appeal. The short point being there that the challenges to the sections after Section 1, which limit the right to bail, are not unconstitutional because of Section 5.1, which is not what is being challenged in this amendment and not what is under consideration. So I have...
Attorney General, you have 5 more minutes.
Thank you very much, Madam President, and it is perhaps the only time since I have had the privilege to speak before you, Madam President, that I might yet go to my full time. So that I say without fear of contradiction, Madam President, the following few things in summary. The legislation which we are asking this House to extend for 1 more year is legislation which we need in order to continue the work which the statistics that I have read out today demonstrate is a work in progress. Point 1. Point 2, nothing in the legislation that we are asking this House to extend takes away the constitutional right of convicted persons to their right to bail before judges of the Supreme Court or the Magistrates Court. It just simply does not. It constrains the right to appeal, to bail, but it preserves that right on regulated terms. And thirdly, I say that if we do not continue the legislation, we will roll back the hand of the clock and expose our citizenry to a very dangerous state of circumstances, which the opposition is happy to point to as heralding some measure by which we should govern when they point to the criminality that is taking place in the streets. The point is we cannot afford to expose our citizenry to that level of criminality where we have the means and the resources, the wisdom and the intelligence to do otherwise, which we are asking this House to do. And lastly, I say, Madam President, that I give the undertaking to the members of this Senate that in the year that we are asking for, I will be coming back before this House to ask this House to join with me in a comprehensive system of bail reform that will satisfy the rights of every citizen of this country. And with those few words, Madam President, I beg to move.
Honourable Senators, at this juncture, the sitting will be suspended for 15 minutes and we will return at 12:50 p.m., which is at 10 to 1. So the sitting is suspended until 10 to 1.